Carlos McWhorter CPA here, and I just saw recently on the news that Antonio Pierce's wife filed bankruptcy because he may be on the hook for $28 million for a bad business deal that he signed back in 2010. And I believe there's some great lessons to extract from this scenario. And just a disclaimer, I don't know everything that's going on in this deal. I don't know these people and I don't know all the details. But from what I gathered from the articles that I read, I believe there's some healthy lessons for us to learn as individuals and even as entrepreneurs as we're navigating the financial markets and trying to get funding for our businesses. Now, lesson number one is a very important lesson that every entrepreneur needs to know, and everybody needs to know, period, I believe. So I've even seen this in my business consulting days, working with the different clients and their small businesses. They have an LLC and then they sign for a loan or some type of funding line of credit. And then they don't understand that they are on the hook personally for this money if the business isn't able to repay the debt. They believe, hey, I have an LLC, I signed for this loan and it's in the LLC's name, it's not in my name. So I created the LLC and that creates protection for my personal assets. Not if you sign a document that has you on the hook as a personal guarantor. That means you and your personal assets are on the hook guaranteeing this loan. And many people don't understand that that's part of the small print. And these companies are very savvy, especially these merchant loan companies that give you very fast funding, these no doc loans. They're not checking any documentation because they understand that in the small print, you are liable. They can come after your wages, your assets, your retirement savings, whatever you have in a bank in your name, they can come after it because you are the personal guarantor. You have to make sure that you understand the document that you're signing and make sure that you are not the personal guarantor. And if you are, you have plenty of assets that can cover the loans that you're taking out. So don't get too excited. And sometimes if it's too good to be true, it's because it is. They're not going to give you $50,000 without any type of collateral. This business fails to pay us back. Oh, well, we just lose out on the money. That's not how those companies stay in business. You have to think about that as well. So in this situation, it says that, Antonio Pierce, former football player and currently head coach of the Raiders, he signed a deal for 2 dealerships. I guess he just made an investment into this deal, and now he's on the hook for 2 loans that total up to over $28 million because he was the personal guarantee on his portion of the loan, or on the loan. He was one of the personal guaranteed people listed, and he says that he didn't recall being that or agreeing to that, but documents have surfaced showing that his name is on those documents as the personal guarantee. So now he may be on the hook for that money. So make sure you understand the deals all the way through. Having an LLC doesn't mean you're not a personal guarantor. Also, you have to understand people may create trust. And even with the trust and even with some legal layers of protection, you can still make a mistake and list yourself as a personal guarantee if you're not careful. Another lesson here is that even though you're a business owner and you have an LLC, you have a business bank account, you still have to make sure that you are separating your personal funds from your business funds. There have been cases where a judge has deemed that your LLC is not separate from your personal assets if you pay for business expenses out of your personal account and pay for personal expenses out of your business account. If a judge sees this and there's any type of case or litigation that's going on, he can deem that your business is not separate from your personal assets, and now your personal assets are not protected from any liability of your business. So you just negated any benefit of having that LLC, that limited liability, by getting rid of all of the limits by mixing your funds. So you have to make sure your funds are separate from your business and your personal, and make sure you keep clean records to support that. Third lesson in this is the most important lesson, I believe. So I'm a CPA, I'm a financial advisor, and it kind of saddens me because this scenario is very avoidable. There's no way he should have been in this scenario. So I'm not going to assume that he did not use a financial advisor or a lawyer. I don't know the situation, he might have, but that financial advisor, that legal team, whoever he used, should have been on his side and protected him from signing as a personal guarantee. So as an advisor, as a CPA, if I'm given a deal from a client, of course, I want to know about the deal. I want to hear details about it. But first and foremost, I'm going to look at those numbers. I'm going to look at the financials. I want to see if it makes sense for the client to get in on this deal. Are they getting in over their head? What's their participation with this type of business? Are they familiar with this business? Are they being put in a position where they can be taken advantage of? I'm thinking about the client and not myself. If he did use professionals in the legal and financial space, they clearly weren't fiduciaries protecting him. Looks like they might have been trying to line up their own pocket. So you got to make sure that you're dealing with a financial advisor or a legal team that's truly a fiduciary, and they will do what's best for you, even if it means less fees for them. So that's our job as certified professionals. So after I look at the financials, I'm going to look at what is the risk to reward ratio. If I understand that he's on the hook for this 28 million, it has to make sense. You're risking 28 million for what reward? And what's the likelihood that the 28 million is going to have to come out of your pocket and versus the likelihood that you have the reward of whatever it is. So it doesn't seem like this was a smart deal to begin with. Again, I'm 100,000 foot view. I don't know the details of the deal, but from someone who has dealt with financial statement audits with dealerships, that is a lot of money to be on the hook for two dealerships as not even a 100% owner, as a potential minority owner. It doesn't really make sense. So once we get all those details about the business and the financials, and even if I do think it's a good deal, we then look to make sure that the client is protected. There are many different avenues that people can go through, but we understand that you can set up a trust, and typically setting up a trust protects you from different types of liability. Now, even if you do have a trust and you still sign a document being personally liable for the debt, the trust is not going to matter when it comes to the court of law. So you have to create these trusts and also making sure you're not the personal guarantor. But just in simple general terms, I think this is a great lesson, not necessarily specific to that particular situation, but in general, if you are trying to make sure that you have layers of protection for your business, you will first set up a trust, and this will be a living trust. You would want this trust in a certain state that grants anonymity. So you want Nevada is a good one. Wyoming is another one that a lot of people like. I myself like that. You have South Dakota and Delaware. New Mexico is another one. There's a few other states that allow it, but these are the ones that I see being utilized the most. Delaware is a good one because the business law in that state is very favorable to businesses and very predictable. If there's any type of litigation, you can pretty much predict how the result of the litigation is going to go because their laws are pretty standard and judgments are pretty predictable. I know that for a fact for Delaware. Some of these other ones haven't dealt with situations where there was any legal matters in those states. However, I know people like using those for anonymity purposes. So you set up a trust typically in one of these states, then you want to set up a holding company. Under that trust. Once you do that, now you set up an LLC under the holding company. Now, I am speaking in general terms. However, if you set up these 3 layers of protection and you invest in the business with this LLC, typically this is a structure that keeps you protected from any type of personal liability. And if there's legal matters that you're dealing with that are outside of this business, typically if there's an asset search, this is a basic setup that kind of protects you and protects this business from popping up in that asset search. So you don't want to name the trust or the holding company or the LLC after you or after your kids. You don't want your family name on it. You're going to have some basic kind of generic names used so that if anybody is doing any type of asset search, there's going to be some protection. Now you have this basic setup, and this is general terms, I'm speaking in. You have this basic setup and you make sure that you're not personally guaranteeing your assets for the debt. And typically you will be protected from this type of scenario. So again, I believe this from a 100,000 foot view, it looks like this scenario is totally avoidable with the basic setup, of course, depending on your situation and jurisdiction and the goals of what you want to do with the assets, whether you want yourself to be the beneficiary or your kids to be the beneficiary later on with the trust. There's so many different avenues you can go with this. I would suggest make sure you talk to a financial advisor or an attorney to make sure that your estate planning is set up properly. And the last lesson here is when you're getting into some of these alternative investments and alternative assets, a few $1,000s up front to a financial advisor or to an attorney to make sure that you're squared away and you don't have to deal with this stuff on the back end. A few $1,000s up front is so much better than possibly millions in liability later on down the road. Many wealthy people, they make sure they have legal counsel and financial counsel on retainer or on their side because they understand the importance of protecting themselves and protecting their legacy and their wealth and not opening up themselves to so much liability just because some details are overlooked. One thing that wealthy people typically understand is that they are wealthy because they're good at what they do. They're not wealthy because they're great on the legal side or on the financial side. They're typically great on the operational side when it comes to whatever business they're dealing with. So they don't mind paying an advisor or an attorney some money up front, again, to protect what they're building. So keep that in mind and don't be afraid to utilize professional services when it's necessary, when it's out of your wheelhouse. Always protect yourself. So I hope you found this video helpful. Can't wait to see you in the next video.